Good morning. Welcome to our estate planning webinar. We'll just wait a couple of minutes for everyone to get into the meeting room and comfortable. So we're recording the webinar so that you can share it with your friends, watch it back with your spouse, or for those people that were unable to make it, they'll be able to jump in and watch this on YouTube as well. So this is just continuing our education series. Today we're focusing on estate planning. So welcome to everyone that's joining us live, as well as who's watched it on YouTube. So I'd love to introduce Anthony as my co-host and co-owner of Absolute Wealth Advisors. Good morning, Anthony.
Thanks, Dean. Thanks for the kind introduction.
Anthony will be here along the way to give us some of the client examples that he's come across and some of the client conversations that can help that journey as well. Good morning, Ian. Good to see you. You're my most frequent attendee, so I certainly appreciate that as well. So Anthony is one of the advisors at Absolute Wealth Advisors, will continue to give us those client journeys, as well as if you have questions at the end that's specific to your personal situation, then you go to talk to your advisor. One of those obviously will be Anthony. So just as a very quick disclaimer, this is a general advice disclaimer, meaning that the content that we discuss here today is general in nature. It's not about your personal financial situation at any point in time. So you need to consider it in conjunction with your financial advisor. Obviously, you're all clients of Absolute Wealth Advisors. So if there's anything that I mention or Anthony mentions, please speak to your advisor specifically about your situation and how we may be able to help you along the way in that context. There's a couple of other webinars that we're having at the moment that we'll continue to keep you updated with via email. Is that we're having an investment update on the 8th of October. So we'll send out some invitations for that shortly. It'll be exactly the same format as the webinar. And then maybe another special guest joining from Absolute Wealth at that time as well to be determined, as well as the cybersecurity webinar. So I've been running these on a quarterly basis for the last 3 quarters, and we'll continue to run these until I get no attendees, because that's how important we think that it is. So we want to keep on the front foot in relation to cybersecurity overall, which is how we're keeping our assets safe, how we're keeping our communication safe, and some of the things that Absolute Wealth Advisors are doing to continue that journey as well. So we'll send out communications around all of those, but if you want to mark them in your calendar right now, you are welcome to do. So getting on to the subject of today. The subject today is Mum and Dad, where's your will and what does it do? So this is a really important subject that we should all be thinking about, both for ourselves individually, our children, depending on our age, as well as our parents. And so for different people that are on the call, obviously there's different ratios there. I'm a member of what's now called the sandwich generation, which is young kids and aging parents at the same time. And so that's a consideration for me as we think about estate planning. And so we're going to go through some really basics of reminding some of our clients what estate planning is, what the components are. That's giving you some context for the documents you may already have, as well as some context for what you may need to chat to your advisor about. And as we go through this slide, I'll be handing over to Anthony to share some thoughts if he has any, and some of those stories as well. So when we think about estate planning from our perspective, from a financial advice perspective, we have access to a lot of information in relation to our clients' financial affairs. We know the structures and entities and places that assets are held, and we've got a pretty good understanding of the law in terms of what happens when someone passes away and how those assets need to go to 2 different generations. And there's complexity based on who the owner is, and there's complexity based on what the written instructions were within the will as well. And so we still need lawyers, and the context of today is not replacing lawyers in any way, but lawyers actually make sure that we've really well documented our wishes so that when we eventually pass away, that document that we put effort into writing actually works. We can't test it. We can theorize in terms of how it would work if something were to happen to one of you, but ultimately we're relying on great drafting and great legal work to make sure that these documents work. So what we're going to do first and foremost is talk through some of these elements of the estate planning documents, and I'm going to, at a relatively high level, just contrast some of the things that we need to have in place as a result. So the first one is obviously the will, And the will takes on two different types of wills when we talk to our clients about it. So we can either have a basic will or a will with a testamentary trust. A really quick and easy way to work out which one that you have is if your will is 3 pages or 4 pages or less, you have a basic will. If your will is closer to 30 pages, you most likely have a will with a testamentary trust, which I'll highlight some of the elements of in a moment. So the basic will, when we have the basic will, we have a couple of roles that are really, really important within our wills in order to give control and permission to certain people. And so the first thing that we always talk to clients about is who is the executor. And so the executor is someone that's legally responsible for executing the instructions within the will. And it can be anyone. It can be a legal firm. It can be the state trustees. It can be your spouse, child, parents, friend down the road in terms of who could take on this responsibility. Anthony, you've got an interesting perspective on who it should be or could be.
The common, feeling around people is it has to be your spouse. And this, I think, in my experience, is driven by the expectation that the executor is an honor that you're bestowing on someone to say, hey, I trust you the most in the entire world, and I want no one else to look after my affairs when I pass away. In reality, being an executor is not a fun job. It's thankless, it's time consuming, and it's hard. And those are the implications of being an executor that maybe you wouldn't want to put on a loved one in a time of probably high stress and lots of other things worrying about. One takeaway from today, hopefully, is to break down the taboo that you're gifting someone the role of being an executor, and that the person that is the executor has a job to do that follows the law, rather than they put it on their CV afterwards that they've done it for you.
Absolutely. And so there's probably some people on the call that have acted as executors, either for close loved ones or friends. And so I can attest to, as what Anthony says, that it is a job that needs to be done, and it can be a technical job as well. And for anyone that's a friend or a family, it's also an unpaid job. Yes, you may be potentially receiving some of the inheritance, but the role itself is an unpaid job at that point in time as well. And so the choice of the executor is really key. We don't, husband and wife, in a very simple example, they don't have to nominate the same people as their executors. It's just the person that's going to do the work. We typically have a backup executor just in case that person is unwilling or unable to act in that role. And then if there was no one else, it would fall on the state trustees to actually take that role on, and they do charge for the role, and they charge quite significantly as a percentage of assets in order to take on that role. So that last element is not normally recommended because it is more expensive through the process. When we have our will, we obviously look at it first and foremost. When we're reading it, we understand who that executor is that takes on the role. And then the second element of that all wills have is instructions around what I would like to happen to my will. To my assets at a very basic level, like who gets my money and where does it go. There's some complexity there that we'll touch on throughout the day, but we deal with that. And for anyone that has children under the age of 18, we actually also make provisions within our will for the guardianship of our children. Obviously, if you have a spouse and that spouse survives you, they retain guardianship. You can't transfer it to anyone else on the death of the first. However, it's really important that we have that guardianship documented within our wills as well to ensure that our children that are under 18 are cared for by the persons that you choose to do. One of the interesting stories that I see around that we've seen over the years is that choice of guardian changes as your children grow through age, and really for two reasons. So you may choose that your guardian is actually your parents at a time in which your children are young. But at some point in time, the children, say they become young teenagers or 10-year-olds, the choice of who you might like to be the guardian for those final 8 years may be different to the first 8 years. The flip side of the reason why that is often the case as well is that our parents are getting older by the time the children get to age 10, that they may not be physically able to take on the role as well as guardians when they're in their later years. And so it's often for our younger clients a consideration of who should be the guardian at some point, and then working with your advisor to review that concept of guardianship of your children. As your parents get older, they may not be that person through that process. One of the things that all wills say is essentially that they cancel and revoke all prior wills from existence. And so this is a really interesting thing. When I had the first slide, hey mum, where's your will and what does it say? It's really important that someone knows where your will is and that someone is clear that this is your last will and testament. So don't store 3 or 4 of your old wills with your current wills, because it can lead to some confusion as to which is the last will that was written when you had mental capacity, which we may touch on as we go through. If we'd like to have a more complicated will, or we have more complicated asset movements, we may choose to have a will with a testamentary trust. Testamentary trust isn't in existence until the date of your death, and it's established through your will and established through date of death being the first part of starting a testamentary trust. And essentially, this is a structure that we can control, very similar to controlling a family trust or a discretionary trust, and assets can flow into the testamentary trust. And the will is the rule book for how that testamentary trust should be operated upon for as long as the trust exists. This is beneficial for the beneficiaries for a couple of different reasons. One that comes to mind at the moment is that you can protect the assets that you've built up potentially from marriage breakdown by having the assets go into the trust, as well as from a concept of asset protection for your children as well. And so if your children happen to be doctors as well, we don't want the asset flowing from you at your level down into the children's direct names, because they may be getting litigated or potentially bankrupt at the time. And so those assets become the children's assets on date of death through the flow of the will. And so the testamentary trust has the ability to avoid and protect the next generation around that. We can get some complexities that deal with how that asset might go through 2 or 3 or 4 generations and how the control of these trusts can exist over time. Anthony, do you want to add anything about the testamentary trust?
Yeah, it's not about trying to control assets beyond the grave, which is a common concept, but often used for trying to keep assets in a bloodline. If that's a priority for a client, that's the marriage breakdown scenario that Dean's talking about there. But yeah, then also asset protection from bankruptcy as well, or other credit-related events to keep it segregated from their personal assets. It is a great strategy.
Absolutely. Thanks, Sam. There's a final tax strategy if your children are under 18, that they can be taxed as adults through the distribution from the testamentary trust. And so for those individuals that have young children, it can be additionally beneficial from that perspective as well. So the will as a document exists when you sign it, and it's witnessed by 2 other people, and then it sits in the drawer until your date of death. However, estate planning has a couple of additional documents that deal with your control of assets and control of your medical side that we need to think about as well at the same time. And so these documents can be alive immediately. And the 2 that are important for us to consider is a power of attorney and the enduring guardianship. And so we'll focus first on the power of attorney. Most people would have heard that term, but that's giving somebody the ability to sign legally on your behalf. And so that sign legally on your behalf power can be effective today, or it could only be effective some date in the future, potentially when you lose mental capacity to enter into contracts yourself. So often we lawyers may produce documents that are called enduring power of attorney, so that the enduring power continues from the date it was given to through the loss of any mental capacity. Remembering the moment you lose mental capacity, you can't actually give a power of attorney anymore. And so it's really important to have these documents in place before, so that we can use them in order to continue to manage your affairs for this period. And so often what happens here is that this is the ability to work with a financial advisor, operate bank accounts, enter into contracts to sell property or to buy property, almost anything where you would leave your signature, obviously in our digital world, we don't leave our signature as much, but it's operating everything in our financial and business worlds. The person that you choose at this point in time is once again often a family member in the context of the choice of giving someone else the power to sign. So that once again can be our spouse in the short term, and making sure once again that we've got a backup so that we can ensure that if our spouse predeceased us, that the document isn't ruined straight away, that we've got a backup that we can rely on through that process. And so sometimes this is our spouse, Anthony, and our children. And so talk about, if we've got two children, who gets the power or how do they share it?
Yeah, it's a tricky one because again, it feels it's an honor that you're bestowing on someone to select it. But there's different things that we consider with our clients about who that might be. A common one actually is, where are your children in terms of a backup? Sometimes if they live overseas and they're not local, it might not be appropriate for them to be a power of attorney because they can't physically sign things if required. They can't visit banks. They can't talk to people. That geography might influence where the selection of the backup. It's also the willingness of your children as well. Sometimes they might not want to be involved, but the only way that you can really understand that is by having the conversation. We're often encouraging our clients to use it. Hey, I spoke to my financial planner today and he mentioned this. Have you ever thought about, as an opener, to have a somewhat maybe initially awkward but probably very important conversation with the people that you're nominating to say, hey, this is what it would entail. Would you want to do that? Because some people might not want that responsibility. And I guess the third part then that we often consider is, in terms of choosing between people, is the dynamics between them as well. Because if for whatever reason people don't get along, if your document says they have to get along from a legal sense, it can just slow things down, make things a lot more difficult and harder to implement. Being aware of the dynamics between people is something really important.
And it's not, I've had this scenario that comes to mind where the three children were the joint power of attorney. And so it's very difficult to get things done, Anthony, just in terms of the practicalities of getting three signatures on one document. In the modern world now, it's very difficult. Everyone has to be identified and certified with the bank, for example. So it can be a complicated situation to get three people on as a power of attorney and then have them all, three of them, deciding through that process. So Rhonda had a really good question, and I'll continue to answer it as we go through. And Rhonda was asking the difference between the power of attorney and the enduring guardianship. And so firstly, we often say power of attorney. The ideal document that we have is an enduring power of attorney. And that's because that document lasts into the period where you've lost mental capacity, which frankly is the most important spot for you to have this document, is that. So we need an enduring power of attorney. When we look at the next document, Rhonda, the next document is called an enduring guardianship. And this is the main document that deals with medical and lifestyle decisions. So the power of attorney is a legal, think of it like banking type of relationship that deals with all the legal side. Enduring guardianship is the document that deals with your physical health and care if you're unable to make all of those decisions yourself. So this could be where you live, the standard of care that you have. The documents go deeper in terms of what medical care that you'd like and not. And finally, at that end of the decision, you can actually document your personal decisions as to whether you'd like your life extended by doctors in the context of life support, or you would like that to be turned off. So this enduring guardianship handles most of those questions around your care and well-being. And I had always emphasized the importance of this document because once again, it removed the decisions from the next generation or a different generation. My example that I used to always talk about in my personal world is I didn't necessarily want my wife and my mother fighting over my medical decisions. Now, one person in common law has the power, which is my wife, but the document just removed any of the discussions because the document ensures that my wishes are taken care of. And so we've got this concept that when we go to our lawyers, we get an enduring power of attorney to deal with the legal side, and we get the enduring guardianship in order to deal with our medical and lifestyle decisions. And so that we cover off most events through those documents. Now, the people that you allocate to each of those roles could be the same or they could be different. I've had situations where one child is the lawyer, so they take on the power of attorney, and one child is the nurse, so they take on the enduring guardianship because that's where their specialties are. And so that is okay, and that's individual decisions along the way. So they're the three documents predominantly that you would, when you went and saw a lawyer, you would get that package. And that's something that the advisors at Absolute can talk to you about, is you get that package of those three documents. Everyone has a will individually. Everyone has an individual power of attorney and an individual enduring guardian. There's a few other complexities in estate planning because there's some assets that sit outside of a will that we actually need to consider as part of your estate plan. Now, you talk to the lawyer and your advisor about these things as well, but the three elements is that at a really high level, superannuation can be dealt with outside of your will. So there's a superannuation trustee that can make at their discretion who receives the money according to the SIS or the Superannuation Act, or you can make a superannuation nomination, and that nomination actually can be different to your will. So superannuation, you can directly choose who the superannuation goes to. You can also choose to have it go into your will so it's dealt with in there. But it's really important that we're understanding our superannuation nominations and also updating these, because some superannuation funds that your money may be invested with have different rules around their nominations. They create expiry dates. They create different, it's called lapsing and non-lapsing, which we just need to get an understanding of with your advisor to make sure you've got the right nomination that deals with your wishes. With investment bonds are created underneath the Life Insurance Act as well. And so it once again has an ability for a nomination and be dealt with outside of your will at the same time. Final document that we think is important but not legally binding in this journey is the concept of a letter of wishes. And so this is the stuff that's not technically law, that can sit outside of the will to give instructions to your family as to why you made certain decisions. And this can be a really important document if you've made some decisions to treat people differently in your will. It allows you to give some context to that decision. We'll get on to challenging a will in a moment, but the letter of wishes builds in that story. It can also build in your wish or desire for certain small things to go to certain people. So if you have a very special wedding ring, as an example, you can write that in your will. That has to go to one person in particular, and then that's legally binding. If we've got a variety of things that we might want to give to a list of people, often the lawyers will encourage that to go into a letter of wishes. Doesn't mean it's legally binding, but very likely that the executor will follow the letter of wishes, because we're talking most likely not about financial assets, but we're actually talking about the family heirlooms that need to go to certain people. So often that gets included within some family wishes as well. And these can get more complicated as wealth increases, because you may wish to give instructions on how you would like money to be managed in the future, or how you would like your children or grandchildren or great-grandchildren to go to particular schools that maybe the assets are funding. So all of this can sit within the letter of wishes, which can then be updated at your leisure without having to go back to see the lawyers as well. Anthony, any thoughts on those three elements before we move on?
People often ask superannuation why would I not just send it to my estate for a superannuation nomination? Because there's certain rules around who it can go to, and broadly it's a spouse or children or your estate. They're the three options. But once your children are over 18, the tax implications become different. And there might be circumstances where, even though you want your children to get your superannuation, it might be, from a tax perspective, better to send it to the estate and then use your will to direct the assets to them for some complicated tax reasons. Why you might not send it to your will, though, is because it avoids the need for probate if it's just handled directly from superannuation. Often is some administration, but the provision of a death certificate and some other documents is enough to release the money from superannuation, as opposed to waiting for the courts to grant probate and go through that process. Investment bonds are even quicker in terms of releasing it with that nomination as well.
Yep, absolutely. So there's been some sad stories from a practical perspective. So if you can imagine that potentially a husband and wife may only have one bank account that they've been using for the last 30 years, and unbeknownst to maybe to the spouse, that it was only in the husband's name. It could, going with our older clients, that could be really common, that the bank account that they've used for 30 years is just in the husband's name. Husband passes away, that we have no ability to get any money for the spouse because she wasn't named on the bank account, and we need to go through the exercise of getting access to some money relatively quickly. It's a good reminder to be checking these things with your advisor and making sure that we've got a plan of that each individual has access to some money in their personal names, because the moment you tell the Commonwealth Bank that someone's deceased, they actually start to lock down accounts, because they, like most people, they can't deal with someone who's deceased. So they can't, the contract law probably fails them at that point in time. So that's the simplicity of some of the things that we wanted to share in terms of estate planning. There are a few complexities that we wanted to raise because every situation is different, which is why talking with your advisor and then a lawyer is really important to get an idea as to whether you're simple or your situation is a little bit more complicated. And so a couple of different things that we know lead to complexity that has to be considered is international assets, first and foremost. So lots of our clients have worked physically in other countries, and also accumulated assets in those other countries, or they've moved to Australia and left assets in other countries. So it's really important that's considered, and actually it may require you to have multiple wills in different jurisdictions, because if you think about having a house in the United States may not honour the will that you've written here in Australia, giving it to your spouse. And if you don't have a document that works well in the United States, then we're following common law in the US, which may be different. So obviously tax implications that would need to be considered at that point in time as well. Second thing is the blended family. So that's our definition of people that have been married a couple of times, and so therefore perhaps have children from two different relationships, or two divorced people come together with children and blend that family together. And so it results in complexity, both in the context of different wealth levels coming together potentially, but also different ages of children. Some clients may be living their second lot of children because they've had their second marriage. And so that also means you may have adult children and young children at the same time from different spouses. And so those children may need different things as a result within their wills. And a blended family makes it complicated, but it really means we've got to spend the time to consider what your wishes are, and understanding those helps the lawyer document the right wishes. We want to make sure that the documentation of your will results in clarity to the next generations, not confusion. And we'll talk about challenging estate in a moment. Next thing that makes estate planning a little bit more complicated is having structures. So if you have a trading company or a private company, a discretionary trust or a business, all of those things lead to complexity because they need to be controlled by someone at the same time. So structures in themselves don't die when you die, and we need to therefore pass the control across to the business. So in terms of a business, we may need a business partner to be the director of the company, or our spouse may become the director of the business, for example. So there's some complexity there. If you're a business owner, we need to deal with the complexity of how that business gets sold to other shareholders, or perhaps it means your spouse is a part owner in the business, which may not be ideal. Companies and trusts in the same context. I hinted about different children's needs as well. So that's when you may have that age difference, which requires children to be treated differently. If you've If you think about what's happening at the moment, perhaps we've helped our older children to buy a house. So we may have lent or gifted them some money, which I'll get onto. At the same time, we haven't yet lent or gifted our 5-year-old child any money. So there may be a need to treat them differently because of age, or they may have some special physical needs that may need to be adjusted for in the will. So if you have someone that needs additional help, we may like to make a provision in your wills to actually give them more money or give their trustee more money such that they're cared for differently. And finally, what makes things a little bit more complicated as well is anything that you've done pre-death in this category of gifting or loans. I've got a complete slide on it into 2 sections, so I'm going to leave it at that for the moment, but it does result in some additional complexity as well. Anthony, anything that I've missed?
Not missed, just to extend on blended families that are becoming more frequent these days, and how we often help clients understand is to model through the implications of, okay, if this event happens, where does the flow of assets end up? In a recent case, once we did that exercise, we discovered that there was an imbalance, that if the husband passed away first in terms of the children ultimately receiving assets, in one situation, one side of the family received 40% and the other side received 60%. But if the spouses, the order of passing away was the other way around, the asset distribution at the end was inverted again, 60 and 40. Instead of the intention was to be 50-50, but just via the maths of the I guess the death order had those negative implications. Just helping people work through the actual dollars implications has been meaningful.
Yep, excellent shared, Anthony. So that's the exercise that your advisor goes through with you, in that we scenario test what would happen if, and we can run those scenarios to run through the numbers as well. So one of the frustrating parts of estate planning, if you're a lawyer, one of the growth areas of legal fees is actually in the challenges to estates. And it is possible and very easy to challenge an estate in the context of, I don't think I was given enough. I was promised something that I didn't receive. And so therefore it's relatively easy to start a challenge. And probably the biggest frustration that I would have around this is that the assets of the estate can be used to challenge the estate. So the individual making the claim doesn't necessarily have to have lots of money to hire lawyers. They're able to lean on the assets of the state in order to fund parts of the legal action. And so firstly, we need to know this in order to be thinking about what could happen and working with our lawyers and advisors around this. So this is New South Wales, but every state based has different rules in relation to this. However, there's an concept of this eligible person. It's really important to see who is an eligible person. And so obviously spouses, former spouses, children in any way, adopted, step or grand, could make a claim. People living with you is interesting. Close personal relationships, dependents, and that's often like, I'm financially dependent on you, or people that were promised something. And so there's famous cases in the context of people were giving someone money on the side that maybe the children or spouse didn't know about. And so that created this dependency, even though that they didn't know that they were creating it, but also promise something. That's actually really common. If I had said to my child, I promise to give you my Porsche when I die, that sentence, and it may not be the Porsche, it may be the farm, or it may be other assets. And so this ability that they felt left out is actually really the motivation that people may have to challenge. But there's often, if you think about someone that's living close to you, if you have a situation where someone's living on your property or someone's living in your house for an extended period of time, it may create this dependency that they felt that they were not given enough, or anything, and therefore they'd like to make this challenge. And so we can't make a bulletproof will, so you can't stop people challenging wills. So it's really important that we're thinking about how everyone might feel in your network, and therefore talking to your advisors about that, such that you can try to be aware of these things and perhaps reduce. In New South Wales, as the only state, they have this concept called notional estate as well, which means that if you had given money to anyone in the last 3 years, that could be clawed back to add to the estate assets. So if you gave away a property in the year before you died and you thought that was good estate planning, and then there was a challenge, that the value of that property could be pulled back into the estate. Once again, complicated, better dealt with at the front end in terms of that, and obviously better dealt with loans and gifts, which we'll get onto in a moment. Anthony, any other side of view of the challenges to estates?
Firstly, I like the picture there, Dean, but just in terms of a semi-recent client experience, was that they had gone through a marriage, they'd remarried, but hadn't realized that when you marry, unless your will specifically said otherwise, a marriage invalidates wills that you have in place, and they hadn't realized that this was the case, and so effectively they didn't have a will, so it was going to definitely be open to a challenge in the event that something happened because the documentation wasn't in place.
Very good reminder. So yes, the marriage does invalidate previous wills. Okay, so the concept that we wanted to share with, because it's a very common spoken about media type of thing, is the bank of mum and dad and gifting and supporting before death. And this should be dealt with your advisor in terms of individually thinking about this as a potential strategy. From an estate planning perspective and today's general advice, we want to make sure that you're putting your oxygen mask on first. And everyone's flown, I'm sure, and they talk about that put your mask on first before helping others. And I really want to reiterate that point when it comes to thinking about how we're supporting other people within your family network, is that we must make sure that your oxygen mask is on first. And so that is your relationship with your financial advisor, to make sure that you have enough money before you go down this path of helping little Johnny. When we get to this point of making the decision that you would like to help, we've got a couple of things that we want to share with you today, just that we need to consider. So firstly, there's two concepts. Do I loan money or do I gift money? And so this is the first element, where a gift is a gift and it's gone forever. A loan is documented and could be an asset of the estate. So if I lent money to Anthony and I documented it in a loan, that's an asset of mine still, because I can call that loan back in and ask to be repaid. If I give him $100, I have no legal recourse to get that money back. And in today's case study, I'm also dead. So there's very little he said, she said on the gift side, because I'm not able to defend my side, and Anthony will continue to say that it was a gift for forever. And so this element of considering as to whether we want to make a loan or a gift is very important. We also need to consider it in the context of how many children that we have and how do we treat them equally, if that's our objective. Or if we don't want to treat them equally, we need to be documenting that in the letter of wishes as well. So the loans versus gift, it's really important to consider that, and if you're considering that it needs to be a loan, that we're putting a proper loan agreement in place to prove to both parties and to third parties that was a loan. And so that helps from a breakdown in relationship perspective whilst they're still alive. It can help because you can be a mortgagee like a bank. If you're lending money to your child to buy a property, you can be the bank and have security over the asset. And then in the event of death, we've got proof that is an asset. Now, the next thing to think about, I have this concept of bank of mum and dad in a different way, is often we are also asked by the banks to provide security. So there's this concept that when little Johnny's going to get a home loan, that the bank can take security over my house as well as the new house in order to do that. What's that? Do you know what it's called off the top of your head, Anthony? Family guarantee or something like that, I believe it's called. But with that guarantee comes risks because you are transferring the title deed of your property to the bank. And so as a result of that, you are at risk of losing your home if your child goes bankrupt or doesn't pay the mortgage or anything like that. So it needs to be considered if you're providing security for an asset. Secondly, when you are loaning money, it is possible for you to obtain security. So if I lent Anthony money to buy his house, I can have the mortgage, which gives me strong title, just the bank does, in order to get access to that money in the future. And so we need to be thinking about how we obtain security. Obviously, as I mentioned, the notional estate comes in as part of this as well. If we are gifting, if you gift all your money to 2 days before you die, there's an issue with that, potentially in New South Wales, so that needs to be considered. And finally, the last way that this works really well is with conversations, family meetings, and then letters of wishes. Time makes everything that was discussed hazy, okay? If you can imagine that we've had clients, I know I look young, I've had clients for 20 years, the conversations that I had 20 years ago about estate planning have been forgotten. Okay. And so if over these 20 years we made different gifts, we helped different people, we have changing wishes, if that's not documented, communicated with everyone in this concept of a family meeting, then it gets lost. And if it gets lost, then when it comes to date of death, we're simply left with the legal side and no history or context. So I think it's really important to make sure that if you're doing things that are not equal and you're doing things before death, that we do a good job to work with your advisors to document those things simply to avoid confusion in the future. Okay, and this is the last slide. This is Anthony. This is discussions with Anthony as well as our other advisors at Absolute Wealth Advisors. So it's things that we need to think about and discuss with your advisor as we go through. So we need to be writing or updating your will at different points in time, most definitely in terms of understanding what's going on. Please talk to your advisor about documenting any gifts that you want to be known as gifts, but still documenting it. And conversely, make sure we're documenting those loans. Thinking about a letter of wishes. I think we would have a template of a letter of wishes and the lawyer would also give it. It's not legally binding, so it can be in a variety of formats through that process. We're highlighting that there is some tax planning that needs to be done around superannuation. So your advisor may have spoken to you already that there's no death tax in Australia as a rule. However, when money exits superannuation and makes its way to adult children, there can be an additional tax of the capital, which could be up to 15%. And so that's a significant dollar figure for clients that have significant monies in superannuation. So it's important to talk to your advisor about what are the strategies in and around superannuation to potentially minimize, remove, or understand, minimize, and then remove what that tax would be. And finally, getting organized. I'm about to share Oprah's book club with you, and there's a lot of different contexts for estate planning. And so a couple of literally funny and interesting things is there's a couple of books out there, which is The Gentle Art of Swedish Death Cleaning. And as I would say, is the next one, Nobody Wants Your Shit. There's a really interesting part about thinking about the second element of estate planning is that what happens when you die and all of your stuff. And if you go into your wardrobe, you've got 17 suits. Your children don't want your 17 suits. And so that's the idea of going through this thing of decluttering before you die. This is not financial advice. The last one, Ian, The Gentle Art of Swedish Death Cleaning, the picture, that's actually on Apple TV. It's a show. So for those that really like the cooking shows, I think this is now the next element of that. I think it's an element that we're not necessarily helping you with, but the idea of this from our perspective of things that I know that Stella and Anthony are doing with some of their clients is that there is this art of death cleaning in relation to your financial situation as well. And so that's things, if you've got a lot of direct shares, we've been organizing those onto platforms so that it's easier. Some of our clients bought CBA shares when they were $5 or thereabouts. And so there's a long term of capital gains tax history, dividend reinvestments, understanding what you bought properties for, things like that. If we don't have the details, we need to collect them with you, because that helps the executor do all of that work as well. Anthony, over to you. Any thoughts? And we will open it up to questions. So if you do have a question, friends, and we'll take you off mute, but you'll have to raise your hand with the button at the top of the screen. A good way of doing it is also turn your camera on, then we'll know that you'd like to talk as well. Anthony?
Look, the conversation, we're talking about it at a high level today, but obviously this is a very personal topic for each and every one of you. But as hard as it is to have the conversations now, it's much better than the car park conversation that we talk about in the future, that when something's happened and the kids, etc., are gathered in the car park and they say, well, what do we do now? So having these conversations now, as hard as they might be, just make that part of the thing, that part of the process so much easier.
Amazing. Thank you. Thank you, Anthony. If there's any questions, type, come off mute. I'll stop the screen share so that I can see everyone. There are no silly questions at all. Probably if you're thinking that someone else may. We obviously can't give you direct answers into your situation, so just ask it for a friend kind of thing, and we'll go from there. Oh, we have a surprise special guest star, Paul Barrett. For those that don't know, Paul Barrett is the other founder of Absolute Wealth Advisors, my business partner of 18 years. So Paul will know how to come off mute very easily. And Paul.
And this is assuming nobody has any other more important questions. But some of the other discussions that you can have with your financial advisors are ways around preventing disputes with family members or potential family members in the future. So there are certain assets which don't necessarily
Paul's pause there, which is very timely. As Paul was saying, there's certain assets that don't flow directly through the estate, and so they're considerations to do it. We got you with your internet, Paul.
Cool.
I finished your sentence, so everything is okay. Is there any other questions? Janelle, you've put your camera on, so thank you. Do you have a question? I might have to unmute you, or you do it from your end. I think it's enabled, so you just have to unmute yourself.
Wait up, Mike.
The mic will be at the top right-hand corner of the screen.
Maybe Ian, do you want to jump in?
And you can have your question, and then if you work it out, otherwise we'll do it afterwards.
But with all the things this government is planning, is there some possibility they could meddle with testamentary trusts?
The trust law as a concept is strong. So some of these benefits in terms of asset protection, controlling who receives the capital, that's obviously been around since the Catholic priests took trustee of people's assets when they were going to war. But the taxation rules can always change. So the reality of maybe the Labor government at the moment may be looking in the future to tax trusts overall. That's something that's been a theme of the past. And that may apply to testamentary trusts as well. And if that were to happen, maybe there's other structures that could achieve a better purpose as a result. But I think the reason why people do it is predominantly through how am I going to control and gift assets to the next generation? And so pretty confident around that side. Do not know, obviously, with governments and debts to repay, what the taxation side will be. But thank you very much for attending. We will send an email with those other dates of events that we are hosting in the future, first and foremost. So please register for those and put those in your diary. We're excited to do these and continue teaching you new things. We will also send this as a video link, so it'll be up on our YouTube channel for Absolute Wealth Advisors, so that you can watch this on Friday night if that's what you would like to do. Otherwise, share it with a friend as well. So thanks very much for coming, and look forward to seeing you again next time.
Thank you.
Thank you.